I'm going to talk from here. Good morning, everybody. This is Amy Gamber at TAR. I'm your Commercial Services Manager, as you may or may not know. Welcome to our webinar today. We're going to be presenting an update on commercial forms, our new forms and our revisions. I'm going to do some administrative items, tell you all how this is going to work, and then we'll get started. This webinar is about an hour. We've been approved for CE credit, but in order to get credit, you have to be present at a local board office or some other location with monitoring. So as some of you will see, we have our remote classrooms and some local board offices taking part here. If you want to do this for CE for our next webinar or series of webinars, get in touch with me or John Hauser in professional development, and we can create a remote classroom for you as well. If you have technical issues with Zoom, please don't call TAR. Our receptionists are great people, but they are not IT experts and they do not know how to fix the Zoom. I am going to give you the number for technical issues with Zoom, which is 888-799-9666 extension 2. Again, 888-799-9666 extension 2. All right. Everybody who's watching is going to be muted while we're going along. If you are participating for credit, when we get to the point where we're asking questions, just wave your hand at us and we will unmute you so that you can ask us questions. If you aren't participating for credit and you have questions, you can use the question box, which is at the bottom of your screen. If you mouse over the screen, you'll see a box that says Q&A. You can type your questions into there and I'll keep track of them for Rick. We'll be answering questions at the end of the presentation. We're recording the webinar, so we'll be posting it on the YouTube channel under the commercial videos playlist, hopefully by the end of the week. Our presenter today is Rick Albers of Kuperman, Orr Albers PC in Austin. Rick is an experienced real estate attorney and a good friend of TAR who largely wrote the new forms, so he is definitely the guy to explain them to you. Many of you know Rick, and it's great to have him with us today. Rick's going to review these forms. He'll take questions at the end, and then I'm going to pop back on at the end and close out a few things. So with that, it's all yours, Rick.
Thank you very much, Amy. It's a pleasure to be here, and thank you very much for inviting me. And I can see all of y'all that are at the various local boards, and I can see Michael in Houston, because he did a great job of fixing their camera. So I see all the rest of you. All right, so we will get started here and talk about what we're going to talk about. Broken this down into four different topics. The first is we're going to talk about a TREC rule change. Then we're going to talk about the recent commercial form revisions. Then we're going to talk about a few new commercial forms. And we'll talk just a little bit about how to obtain the forms. I think all of y'all know how to do that already, but I'm going to go through that part super fast. Those of you who have seen me speak or heard me speak before know that almost always, but not always, I start off with this slide because there's still confusion about the difference between TREC and TAR. So we're going to go through that because that's part of the basis of this speech as well. TREC is the Texas Real Estate Commission. It's the governmental agency that is the licensing agency that gives you your license. Actually, they don't give you your license. You earn your license through education and passing a test and paying them a fee, but they're the ones you get your license from. TAR has nothing to do with the state of Texas, other than it's in Texas. It's the Texas Association of Realtors. It is a professional trade organization. It gives you all kinds of services like these forms that we're going to talk about today. It also attempts to influence the Texas legislature as a whole and TREC itself, and when TREC passes its rules and regulations. This is a distinction between TREC and TAR that y'all need to keep in mind. Remember, TREC promulgates a lot of residential forms. TREC does not promulgate any commercial forms. They do promulgate a couple of addenda and notice forms that can be used for commercial purposes, but TREC does not promulgate any forms that are for exclusive commercial use. TAR has stepped in to fill that void, and they produce these statewide commercial forms. So remember, one of the things that TAR does is that it attempts to influence what TREC does, gets them to change the rules. Well, there is a rule change that becomes effective today. So y'all are new to hear about this. It is now in effect for 10 hours and 8 minutes or so. And this rule deals with the forms. And in this presentation, I'm not going to go through the revised rule line by line because it's very confusing to go through it line by line. I'm going to paraphrase it, and this is how I summarize the rule. It is not necessarily how anybody else would summarize the rule, but it's how I summarize it. And the rule says licensees may only bring a contract or a lease. So that's a sales contract, a purchase contract, or a lease to the transaction if that form is approved by TREC, or the form is prepared by a lawyer licensed in Texas, or prepared by a trade association in consultation with one or more licensed lawyers. That's it. Those are your only two choices if you are bringing the form to the transaction. If you are representing a landlord and a landlord's got this big long lease that the landlord wants to use, that's fine because the landlord's bringing the form to the transaction. If you're selling a big office building downtown and that seller's got an attorney or the buyer's got an attorney and that attorney's drafted the contract, well, the seller or the buyer is bringing that form to the transaction. So you're okay with that. But if you're bringing the form, if nobody else is bringing a form to the transaction and you're the one who's laying that form on the table and saying, here, let's use this form, it has to be one of these two things. It either has to be a form promulgated by TREC. Remember, TREC doesn't promulgate any commercial forms, so that one's out for you. So it has to be, if you are bringing a form to the transaction, beginning today, it has to be prepared by a lawyer licensed in Texas or a trade association in consultation with one or more licensed lawyers. Let's drill down a little bit more. If that form is prepared by an attorney or trade association, the form has to include some new things. It has to include on the face of the form or somewhere on the form the name of the lawyer or the trade association who prepared the form. So you can't come in with a blank form that was prepared by some lawyer that doesn't have that lawyer's name on it somewhere. When you come in with the TAR forms, it's got TAR at the top. So it's got the name of the trade association at the top. It also must have the name of the broker for whom the form was prepared, or the trade association for whom the form was prepared. So once again, with the TAR forms, it was prepared for TAR, by TAR. It's there at the top. That form complies with this revised rule. The form must have a statement in it for the type of transaction for which the lawyer or the trade association has approved the use of the form. Once again, all the TAR forms have that already. They've got the title itself tells you what type of transaction that form has been approved for. And if there are any restrictions on the use of that form, the restrictions must be listed. So once again, all the TAR forms comply with this. If you're bringing a form, even if you're doing residential, and this applies to residential and commercial the same, The TAA, the Texas Apartment Association forms, fall into these same categories. So those forms work if you're going to use those forms. There are other professional associations who prepare forms up in the Dallas area. There's NTCAR. That's another professional association. They're a local chapter of TAR. And so those forms work as well. But you either have to have the form prepared by an attorney with all this stuff on it, or it needs to be prepared by a trade association with all this stuff on it. Drilling down one more step is if the form is an addendum to a TREC promulgated contract or lease. Okay, now once again, for most people listening to this who are doing commercial, this isn't going to apply to you because TREC doesn't promulgate any commercial forms. But if you're using the TREC 1 to 4 family form and you're using a standard addendum, when I say standard addendum, an addendum that you have always used in the past on this TREC contract, on the TREC 1 to 4 contract, that's not a TREC promulgated addendum, and you're changing some things in that contract, all these things apply. That new addendum has to have a statement about how the addendum changes the TREC form, and it has to reference the paragraph that addendum changes, the paragraph in the contract that form changes. It has to have a statement in that addendum that it is not a mandatory TREC form, and it has to have a statement saying, quote, TREC rules prohibit real estate license holders from giving legal advice, period, end quote. That's the new rule. So again, this last section, y'all can pretty much not be too concerned about if you're doing a strict commercial practice and not doing anything residential, but your residential friends are going to have to be doing some new things. Again, if they are bringing the amendment to the contract or the amendment to the lease to the table. If one of the principals is bringing the form, none of this applies. Okay, so let's talk about the TA. So that's the background of things that have changed as of today. And Amy's telling me she has questions, but I'm going to make everybody wait for their questions to the end. Gotcha. All right, TAR forms. There are 103 forms in the TAR library that can be used for commercial purposes. 49 of those forms are used exclusively for commercial purposes, and then there's an additional 54 forms that do double duty, or sometimes triple duty. Some of them are used for commercial and farm and ranch. Some of them are used for commercial and residential and farm and ranch. But you have TARs provides you a very nice library of commercial forms, 103 potential forms. What the speech is supposed to be about, and we're finally getting to it, is what has changed in the TAR commercial forms. So there are 2 dates that I'm going to talk about. This first slide, and I'm sorry, this slide's is one of the 2 busiest that I have. Effective April 1 of this year, TAR revised 10 forms and created 4 new forms. And they're in these categories here, where there are 3 forms in commercial and let me back up. The TAR numbers their forms, and I didn't prepare a slide on the numbering scheme, but the form numbers are all 4 digits. So when you get to the 1800, the 1801, 1802 form, the 1800 series is all commercial contracts. And when you get to the 1900 series, it's a different type. And when you get to the 2000 series, it's a different type of form. And in bold here, I've got the headings from those different categories of forms. So there are 3 revised commercial contracts in the category of commercial contract addenda and related forms. There are 3 revised forms and 2 new forms. In commercial lease and addenda, there are 3 revised forms and 2 new forms. And in the commercial listing addenda, there's one revised form. Effective earlier in the year, on February 1, we've got 3 revised forms and 4 new forms. These forms are in the category of additional forms. These forms are the forms that do double duty, that can be used, some for residential and commercial, some for commercial and farm and ranch, back and forth. We're going to go through all these forms, and I'm going to try to get through all of them in this presentation. So the first one we're going to talk about in commercial contracts, actually the first 2 are the numbers I just talked about, 1801 and 1802, the improved property contract and the unimproved property contract. They're very, very similar. If you've ever laid them down side by side, the words are 95% the same. And the 2, it's just one's for improved property and one is for unimproved property. So let's go to the improved property contract, and I'll go through the changes with you. What I've done is I've highlighted the changes in yellow. I've highlighted the major changes. Things like page numbers that have changed and the form dates down the bottom left-hand corner, I haven't highlighted that. So the first change, and I'm going to start with the improved property contract, then I'm going to switch over to the unimproved. I'm going to do the part of the improved contract that is only in the improved contract, and when I get down to the stuff that's the same in both, I'm going to switch over to the unimproved. So here, and again, this first highlighted part is in a part of the contract that is in parentheses and in italics. All these words are in parentheses and italics. That is not a part of the binding contract. Those are instructions to you in filling out the contract. So this third line says, if the property is a condominium, attach the commercial condominium addendum, which is TAR 1930. What's added is or TAR 1946, and that's added because that's a brand new form. The TAR 1930 turns this standard improved contract into a condominium contract for medical condominium or medical office condominium or regular office condominium, whatever it may be. What we didn't have is a way to have a contract for a condominium unit that was under construction. This 1930 contemplated a completed construction unit. So the new form 1946, which we'll hit in a little bit, is for incomplete construction for a condominium. That's all that is. So we scroll down to the next thing, which is in the survey section. So we're in section 6, paragraph B, which is the survey. And we've changed the type of survey. It used to be an ALTA ACSM land title survey. Now it's an ALTA NSPS survey. ACSM stands for American Congress on Surveying and Mapping. They changed their name. Their name is now National Society of Professional Surveyors. So since they changed their name, we had to change the form. So that's all that is in paragraph 1 and 2. In paragraph 3 of the survey, this used to say that when the seller delivers his old copy of his existing survey, that if the title company doesn't approve of that survey, that the seller had to go out and get a new survey. And then it provided that the buyer would have to reimburse a portion of the cost. The form's now been changed such that it is not that the seller has to get the survey. It's that either the seller or the buyer, you check the box. Other than that, it's all the same. Everything else that's highlighted is just to make it work so that you have a choice that either the seller or the buyer is going to get the new survey if the title company doesn't approve the survey. In paragraph D, normally there's a blank here to start out with that is normally filled in with however many days it is that the buyer has to object to the title objections. We call them the title objections, but the the time frame doesn't start until the buyer gets four things. Four things. Those things are the title insurance commitment, copies of the documents evidencing the title exceptions that are referred to in the title insurance commitment, any required survey, and any required UCC search. Apparently, some people were having an issue with, does the clock start with each one of those, or is it the last of them? And we've just made it clear. It's always supposed to have been the last. The clock starts ticking when you get the last of those, but we've made it clear here. What we've done in the last part of the paragraph is to give an additional review period if the title insurance commitment is updated, or if the survey is updated later on and there's something new on it that wasn't there to start out with. Well, you ought to have the right to object again. And so that's what this does. This gives you the right to object again. It gives you the same number of days to object to whatever has changed. You don't get a second bite at the apple on things that you've seen before, but anything that's new on it, you get the same number of days to object to. All right, so that's where I'm going to stop on this one, and I'm going to go to the unimproved property contract. And let me scroll down to that part. Real reason I'm switching is the red line is better on this one than it was on the other one. So in paragraph 7B in the feasibility period, we've broken it down into two sections, two main sections before. We still have the two sections, the two what I'll call subsections, where you give the independent consideration one of two ways. The first way, which is the way most people do, is that the independent consideration is that part of the earnest money. If you terminate the contract during the feasibility period, you get the earnest money back less the amount that's in this blank, and the seller gets that remainder, that amount in blank, as the independent consideration. And part two is the seller gets a check from the buyer in that amount, and it's not deducted from the earnest money. So we made that paragraph 1 to talk about the independent consideration, and we've added paragraph 2. This is an automatic feasibility period extension if you want to use it. You don't have to use it. This is new, and some people, it might be a little controversial to some people, but the brokers on the committee wanted to try this. So this is an automatic feasibility extension. You put in the blank however many days the automatic extension is, and to buy the extension, you have to put up additional earnest money in blank amount. And that's all it is. So the buyer can easily extend the feasibility period by giving notice that he's extending it and posting the additional earnest money with the title company. That earnest money is applied to the sales price. It is not a fee that is given to the seller for the extension. So there was a lot of talk in the committee about that. The consensus among the group was this is the way it's normally done, is that it's just additional earnest money is posted. I know there are plenty of times when it's not done exactly this way, but I think I'll have to agree in that more often than not, it's done this way. But you can modify it if you need to, assuming you comply with the TREC rules. So in the delivery of property information, in delivering leases, we have included any mineral leases. So if there are any active mineral leases, those need to be delivered at the same time, assuming that box is checked. In the return of property information section, if the buyer terminates during the feasibility period, paragraph B said that the buyer had to delete or destroy all electronic versions of the items. In paragraph D, that the seller delivered to buyer or that buyer copied, and we expanded it to say copied in any format, just to make sure that the buyer has to get rid of all the information, no matter how he got it. And then C is if you're delivering inspection reports, just making it abundantly clear that they have to be delivered to the seller. I think that was pretty much implied, but just cleaning up a little bit. And we do make mistakes, and the printers make mistakes. I can't really tell you who did this mistake, but this sentence was wrong, and because it said that it's going to be in an amount sufficient to comply applicable law. The word with just wasn't in there after however many times we proofread it. But we found it this time, and so it's in there now. I think there's one more down here, and that is in the list of potential addenda or common addenda, we included the form. It's just an information form about mineral clauses in contracts. Minerals are becoming more and more a thing in regular commercial real estate and residential real estate, believe it or not. Then there are some additional notices in the notice section, paragraph 25 additional notice section. What we've done is whenever we reference a form, we try to give the number of that form in the TAR library. And TAR had a form for tidally influenced submerged land, so all this is along the coast. And so we've just put in a reference to that pre-existing form, which was TAR 1915, and then a similar form for property located seaward of the Gulf Intercoastal Waterway, and that's form 1916. The last thing we added was this notice, which is I, which is license holder disclosure. And this is where you as a license holder have to disclose, if you are a principal in the transaction and you hold a license, you have to disclose to the other side that you're a principal in the transaction and you hold a license. So many, many years ago, those of you who are as old as I am, if there's any of y'all out there, the TAR lease used to have two check boxes for this, and that got taken out quite some time ago. But the way you have to disclose and what you have to disclose has changed in the past 4 or 6 years, I think it was. And TREC has put a similar disclosure in their residential forms, so we thought it was time to put it back in the commercial forms. And what the law says now, and this is just a reminder to you that you need to disclose, there's a blank down here for you to disclose whatever it is you need to disclose if it's applicable. But you now have to disclose if you are a principal in the transaction, or if your spouse is a principal, or your parent, or your child, or a business entity that you own 10% or more of. Nope, I said that wrong. It's a business entity that you own more than 10% of. So if you own 10%, technically you don't have to disclose, but I would recommend that you do it anyway. So that's the major changes. Those two forms have got most of the changes. So I'm going to buzz through everything else. The next is the commercial letter of intent to purchase. The only changes that we have on that are down at the, and I didn't highlight this, sorry about that. We forgot to put it, or again, I'll say it was the printer, didn't put initial blocks at the bottom of the second page. And strangely enough, at the end of this sentence, there was a comma, not a period. So we have fixed that. And you may think that that's a minor thing, but it really isn't. Punctuation makes a big deal, especially to us attorneys, because commas save lives. If you look at this sentence, let's eat grandpa, it means something very different than let's eat grandpa. In fact, just recently, there was a case in Maine. There was a lawsuit in Maine, and it was a business, actually it was the Oakhurst Dairy in, she heard this story. Oakhurst Dairy in Maine had a retirement plan, no, I'm sorry, not retirement plan, an overtime policy. And it said who gets overtime at time and a half pay and who doesn't. And they interpreted the sentence one way. The court said, no, your interpretation is wrong. You're interpreting it that the truck drivers are not liable, don't get overtime pay at time and a half, but because you failed to put one comma in one sentence, the court rules that those truck drivers do get time and a half overtime. Total it up, $10 million. So that was a $10 million comma. And let me go down that road just a little bit more. One of the reasons that TREC is starting to come down a little bit harder on licensees providing forms and how licensees fill out the special provisions is they're forgetting commas. They're putting in sentences that don't make sense. And they really are practicing law, and they're not doing a very good job of it. So TREC is going to start watching all that a little bit better. And when I talk about practicing law, when you bring a form to the transaction, you are practicing law. That is under the definition of practicing law. By bringing a form to the transaction, you are saying, I recommend that you use this legal document in this transaction. You get off the hook if you use a form that's approved by TREC or one that follows the procedure that we just talked about that's produced by a trade association. Oh, and so let me go back and talk about that. If you think that rule is onerous, you should have seen the first draft of it. It was horrible. And that's where your money spent with TAR came to great play. Because I will guarantee you, you can live with this rule. You could not have lived with the way it was before. And TAR is the one who made it who at least made it livable. All right, so let's go to the section of commercial contract addenda and related forms. The first one is the commercial condominium addendum. And this is just, we've added that when you purchase a condominium, not only are you purchasing a parking area, but also possibly storage areas. So we're including the storage areas now. In fact, there's a contract on my desk that's a commercial condominium that comes with 6 parking spaces and 2 storage areas. And that's the only thing we did on that one. On the commercial contract amendment, and let me go back. No, I'll go back and click this first. So now we're going to do the commercial contract amendment. The way this, and the amendment is just the basic kind of things that you would do in an amendment to the contract. We added in that you can change the legal description with an attachment. That thought was not in there before. The next one is the commercial contract special provisions addendum. Again, just a super minor change. In most of the forms, we've got 2 lines for the buyer's name and 2 lines for the seller's name. In this form, we only had 1. We actually got complaints from people who said, I really do need that second line to get my long buyer and seller names in. So we got that second line in there. In commercial lease and addenda, the commercial lease construction addendum, which is for landlord to complete construction, and the commercial lease construction addendum for tenant to complete construction. I'm going to take both of those at the same time. And here we just put a clause in that made it clear that anything in this addendum controls in the event that there's a conflict with the rest of the contract. And made reference to another TAR form, which is 2113, which is the commercial lease acceptance form. The commercial lease application has a couple of changes on it. Again, there's a typo, I'll call it. This should have said LTD for limited partnership, and now it does. Instead of attaching the various information, the balance sheet, income statement, and other items to this form, we're now allowing that it, alternatively, it can be delivered in a secure manner, some kind of online type delivery. And then, since we're talking about online delivery, have a warning about data security. Data security is becoming bigger and bigger every day. So it's just a warning to everybody that if you're delivering personal information, that is non-public personal information like bank account numbers or other financial information, that you should do it in a secure manner. All right, in the commercial listing addenda and related items, the property condition statement. The property condition statement was written originally for a seller to attach to a contract if they want to use it. Well, landlords in lease situations might want to use it as well. So we have gone through it and made it applicable to both sellers in a sales transaction and landlords in a lease transaction. And I'm just gonna, I think that's the only part I want to tell you about. I'm gonna skip some of the more minor issues just so I'm staying on time. So that's the commercial property condition statement. The new commercial forms, there's a new contract addenda, which is commercial request for evaluation materials and confidentiality agreement. I have a feeling y'all might like this one. This is for when you put out a request for proposals and you're the listing agent, and a buyer comes up, the prospective buyer comes up and says, I want to get the package of information on this. This is a form that you can get them to fill out that says that they're going to use the evaluation materials only to evaluate the property and purchase it. They're going to keep it confidential. And it's a nice little form. We couldn't keep it to one page as hard as I tried, but it's just a page and a little bit more. But I think y'all might find that new form somewhat helpful. Then there's the commercial contract condominium addendum for incomplete construction. This is the one I talked about before. It is just like the other addendum that makes the regular commercial contract into a condominium contract, but it adds all the things that are needed because the condominium has not been fully constructed at this point. All right. There's also a new commercial lease special provisions. We didn't have and all that is a blank form because the special provisions section isn't big enough in the lease for you, and you just need a little more space. So you now have a form like that. We've had one for the contract for quite some time. And then a commercial sublease guarantee. We have a TAR commercial sublease, but there hasn't been a companion guarantee for it. So this is a guarantee for the subtenant, for the sublessee to sign to guarantee the sublessor that the subtenant's gonna pay the money, pay the rent, and perform the lease obligations. Additional revised forms, so these are the forms that do double duty. The first one is a general information and notice to buyers and sellers. And this is, I don't know that many commercial brokers use it, but you might want to start thinking about it. This is a CYA form for you that tells your client everything that you should be telling them that you might forget about. Talks about environmental concerns, talks about expansive soils, FIRPTA, the Foreign Investment in Real Property Tax Act, is a clause that we added in. The federal government is watching the foreigners much more closely these days, and this talks about how the buyer might have to withhold up to 15% of the money and turn it into the Internal Revenue Service. Some buyers get real upset about that if they learn about that at the closing table, and if you give this to them with your listing presentation, at least you can say that you have told them or warned them before, even if you didn't go through the whole contract, through the whole form with them. We added a disclaimer about permits, just to remind, and this is big in leases, that might need a permit to do what you're going to do in the property. You might need a permit if you're going to construct something on the property. Included are restrictions on property near an international border. There are restrictions about water and sewage, about the property having water and sewage. Surveillance is also a new hot topic, more so in residential than commercial, but a lot of people have surveillance cameras, security cameras, and folks have been watching, the owners of the properties have been watching the new tenants or the new buyers come through the property and watch their reaction as their broker is showing them the property. There have also been cases where the buyers or the tenants coming through have been photographing the interior without the consent of the owner. So that's just some little warnings about those kinds of things. All right, now let's go to contract addenda. These two are just your basic seller's estimated net proceeds. It's just a form to figure out the seller's estimated net proceeds in a sales transaction, and the approximation of buyer's costs is a very similar form to go through that helps you walk through to figure out what the closing costs are going to be for the buyer. So a couple of more additional forms. There's a representation disclosure. TREC says, y'all are familiar with the IABS, the Information About Brokerage Services form, and you all know that you're supposed to deliver that at the time that you have a first substantive discussion about a particular piece of property. But before that time, TREC says you have to disclose who you represent. And what this first sentence says is exactly what the law is. It says, Texas law requires a real estate license holder who represents a party in a proposed real estate transaction to disclose orally or in writing. Or in writing, look at that. The representation that at the license holder's first contact with another party to the transaction or another license holder who represents another party to the transaction. So hopefully y'all all doing that. I mean, when you first walk up to somebody, you say, hey, I represent the seller or I represent the buyer. And that's what you're supposed to do. But if you want to get it in writing, here's a form that you can get it in writing. That was the representation disclosure. There's a notice of withdrawal of offer. This is a new form which might be helpful in both residential and commercial transactions, and it is exactly what it says. It's a notice of withdrawal of offer. Whoever's got the offer on the table, be it the seller or the buyer, if they want to withdraw that offer, this is a great form to use. It's short, sweet, it gets to the point, and it allows you to do it. In the TAR commercial contract, the last paragraph has got a blank for a date that you can fill in that offer to buy or to sell automatically expires, but that's just the date it automatically expires. That clause is not a requirement that you keep that offer open until that date. If you decide a few days earlier that you want to revoke that offer before that deadline date, you can use this form and revoke it. And then two notices. two new notices. One is a wire fraud warning, and one is an information regarding windstorm and hail insurance. The wire fraud warning, hopefully everybody has heard about the wire fraud and the rampant wire fraud in connection with the title companies. And I'll tell you, it's mostly with people that have web-based email. If they have a Hotmail account, a Google account, some web-based email, and somebody else gets their password and their username, and you can log on to your email account with on as many computers as you want at the same time. So the crook is watching your email, watching it go back and forth. They know that you're in a closing transaction because they're just reading all of your emails. And when it comes time for the wiring instructions to come, the crook then spoofs an email from the title company to the buyer and says, here are the wiring instructions. Wire them to my account. And when you wire them to that crook's account, the money is gone. And the person who is at fault is actually the buyer, because it's the buyer's email that got hacked. It isn't the title company's email that got hacked. This is a huge, huge issue, and warning your clients about it is one of the best things you can do. The last form I'm going to talk about is the information regarding windstorm and hail insurance for certain properties. This is a new form. Hurricane Harvey has kind of brought this on a little bit. And it's for the coastal counties. And if you want to know who the coastal counties are, you can just read this form, because it says, here are the coastal counties. Right here, the coastal counties are Aransas, Brazoria, Calhoun, Cameron, Chambers, Galveston, Jefferson, Kennedy, Clayburgh, Matagorda, Nueces, Refugio, San Patricio, and Willacy. And then it gives the second tier counties after that, one county back from the coast. Getting insurance, getting windstorm insurance can be a tough requirement to fulfill. If you can't get it anywhere else, there is the Texas Windstorm Insurance Association, which is great. I've had experience with them. They have paid when they need to pay. The problem is it is administered by the state. They're running out of money, and they're running out of money rapidly. So you need to get your legislators to fund the Texas Windstorm Insurance Association, or if you need to buy it sooner rather than later. Buy it before it goes away. All right. So I'm going to take just a couple of minutes about obtaining access to the forms, and then I'll take a few questions. You can get access for the forms through the TAR website. Hopefully everybody who's listening to this knows how to do that. And there are also some licensed providers that TAR has licensed. They've licensed .loop and Instanet Solutions. And both of them have some transaction platforms, and you can get the forms. If you're a member of TAR, you can get the forms through those two providers as well. If you go to the TAR website, which is TexasRealestate.com, it used to be TexasRealtors.com. It still works. It points you to TexasRealestate.com. It's 2 letters less to type, so I still type it. You can get access through the TAR website. You can get to the forms through zip forms, or you can download them as PDF files. This is and TAR changed updated the website just not too long ago. And so this is what it looks like now. It's got 2 tabs it's got a tab on the left-hand side for buyers, sellers, and renters, and that's what comes up initially. And on the right-hand side, it's got for realtor members. And you can tell you're on the buyers and sellers and renters because the tab's just a little bit higher over here, and it kind of looks like this is all the same color here. When you click on the for realtor members, before that I wanted to say here, you can click on zip form and go straight to zip forms. And that's the way you get to zip forms on the new website. There used to be another way to get to it in the old website, but this is the way you use it all the time on the new website. But if you click on the 4 realtor members, then you get the darker blue all the way across, and you're on the realtor side of the website. And then there is a legal and ethics tab, and if you click on that, you get to a page with this, which has the forms, and you can, the top one is blank form downloads, has a little lock beside it. That means only realtors that are logged in can access it. The general public can't help it, can't access that. And then we have zip form help, and form changes will get you to the new forms, and a red line's very similar to the ones that I just used. Actually, I used the ones from this website. So you can see what the changes were on the most recent forms that have been produced. And at that point, I'm going to stop and have a few minutes for questions. So, and I believe what we're going to do, people that are at their local association, if they've got questions, raise your hand, we'll unmute you, and we'll take your questions first. If you're just in your office or at home on your computer, type your questions, and Amy is going to go through them and give me the questions. And we have a hand raised in Houston.
All right.
And hold on, Amy's going to make it so I can hear you.
Trying.
We think Amy's going to make it so I can hear you. Maybe.
Can you hear me?
Aha, now we can hear you.
Okay, thanks, Rick. So the requirements associated with bringing a form to the transaction that were discussed, I believe it was on slide 2.
Yes.
Are those still applicable if the licensee is actually acting as a principal in the transaction?
Excellent. Can everybody hear the question, or do I need to repeat it?
I don't know. Did
Okay.
you guys hear that?
Regardless, I'm going to repeat the question. The question is, with the licensee, does the rule about the licensee bringing the forms to the, having to use the types of forms that I talked about, having to bring those forms to the transaction, apply if the licensee is a principal in the transaction? The answer is no, because the rule is if you're a licensee and you're bringing the form to the transaction, you have to do those 2 things. But if a principal to the transaction brings the form, then the rule doesn't apply at all, because you're not bringing the form. Now, I understand that you are the same person. You are a principal and you are a licensee, but being a principal trumps being a licensee in this instance. So if you're a principal, you can bring any form you want to bring. I don't care who prepared it. You can prepare it. Anybody else can prepare it. You're not practicing law if you prepare a form and you are a principal to the transaction. Some people will say you have a fool for a client, but you can certainly do that. But then remember, showed you at the very bottom of the form now, there is a place to disclose that you are a principal to the transaction. At the bottom of the contract form, there's a place to disclose that you're a principal to a transaction. All right. Anybody?
We have a question in Lubbock, and I'm so enamored of your little question mark there.
Oh, look at that. Oh, I didn't see the hand raised.
Super clever. We have a new standard in remote classroom usage,
Yes,
people.
we do.
Well done. Well done. All right. So,
Okay, so
go
we're
ahead,
gonna-
guys. I've unmuted you.
Are we live now?
Yeah.
Can you hear us?
We can hear you.
Question comes into if your landlord has a lease form and one of our forms can be useful within the transaction, can you do a mix and match?
Okay. So the question is, and by the way, just for those of y'all who can't see the screen that I'm seeing, the way Lubbock raised their hand was they had a big sign with a question mark on it. Really comfortable for those of us in this room. Anyway, so the question is, if lease transaction, the landlord has its own lease form, but the licensee has got some other forms that the licensee wants to add to, like an addendum or something to the contract, to the lease. Is that what the question is?
Yes.
Okay, so the answer is yes. So the answer is no, you cannot do that, because you are bringing a form, or you are bringing an addenda. You're bringing a legal document to the transaction. The landlord bringing the form to start out with is great, because that's outside of the rule. It's one of the principles to the transaction is bringing the form in. But if you then say, we don't like your form, or we think your form can be improved with our piece of paper here, you're practicing law. And you can't do that. And to bring that piece of paper, now it either has to be a piece of paper that is a TAR amendment, or some other professional association's amendment, or an amendment that was done by an attorney. But if it's done by an attorney, it has to have the attorney's name on it. It has to have your name on it as a broker, and it has to be specific for that transaction. It's not a broad form. Sorry.
I have a follow-up that was typed into that I'm going to pop in, because it says we use TAR amendments to amend non-TAR leases all the time. We're allowed to do it because we're bringing the form and it's approved. But they're not a principal? Is that what?
Yeah, okay. So yes, you can bring the TAR. You have to be careful about that. Technically, under the rule, there's nothing wrong with using a TAR addendum to modify the lease that the landlord brought to the transaction, or to modify the contract that the seller brought to the transaction. You're okay with TREC with that. However, some of the TAR forms reference paragraph numbers in the TAR contracts or the TAR leases. And so you need to make sure that,
says that right there.
if
Sometimes the paragraph section references don't work.
Right. The paragraph sections might not work all the time. And in that case, if you change the reference numbers, technically you're going to be in violation of the TREC rule, but I don't think anybody's going to bust you for it. The rule is brand new. The rule is 11 hours old. TREC hasn't enforced it yet.
Yeah.
Trust me.
All right, I'm going to pop in and say that it is 11 o'clock now, and so everybody who's looking to fulfill their CE requirement has done so. We have a lot of questions still on in the lists, and we may have some more questions there. So you need to let me know how long you can stay, if you can stay at all. I can forward these questions to you outside of this space.
Actually, it's easier for me to stay here. I'm willing to stay for as long as you want to keep this feed going. So, everybody else who's out there, though, is free to leave. Right. But if you want to listen to the answers to everybody else's question, stick around.
And we're not going to turn off, guys. I see hands being waved and all that good stuff. So we will get to you. I just wanted to let everybody who had to leave after an hour know that your CE is fulfilled now. So.
But wait, I have a question. In Houston, were you waving goodbye, or were you saying you have a question?
Here, let me unmute them.
Oh, wait, we have.
I think he was waving goodbye.
Okay.
All right. Goodbye.
All right. Okie dokie. Thanks, Houston. All right. So
No, now Houston has a question.
Now Houston has another question.
Yes.
All right. Where'd you go?
Hold on, we're going to get Houston on.
All right. Here's Houston, and we'll get everybody. Don't worry. Okay. So Houston, you're live.
Oh, did we have?
No, it's Houston. I'm sorry. It's KW Commercial. I'm sorry.
Okay. All right.
I'm so sorry.
Okay. Unmute. Oh, okay. I see you there. Okay. Now you're good to go.
No, you have Lubbock.
Texas Gulf. I have Lubbock too.
My question revolves around, well, the first issues you addressed was on the commercial contract, the extension of the feasibility period, and that the agreed upon fee would be paid direct to the title company. I don't see the option in there where the fee is paid direct to the seller and the title company is notified, thereby avoiding a future dispute over the quote earnest money.
Okay, so the question is in connection with the new clause in the feasibility section of the sales contract and what I'm calling the automatic, or rather pre-negotiated extension of the feasibility period. And the question was about the option of delivering the fee directly to the seller. And there is no option in that paragraph as it is written currently. The way it is written currently is that the additional money for the extension of the option period is not a fee. It's not a fee in any way, shape, or form. It is merely additional earnest money that is delivered to the title company. So it's not delivered to the seller, and it's not delivered to the seller because it's not a fee. It's just additional earnest money. We discussed that in the committee, and the brokers involved wanted to go with this one single option for the first try through with this. I think that when the forms are revised again, if you want an option that says if you want multiple options, if you want to say that to extend the feasibility period, you got to put up additional earnest money with the title company, or you have to pay a fee that is a fee directly to the seller. We can put that option in, but it's not there now. You know, and we could even break it down and say, and that fee is considered to be additional earnest money, or that fee is not considered to be additional earnest money. But that's not the way the contract is yet. That may be the next evolution. If you want it, give a comment. You can always make comments.
Forms at TexasRealtors.com.
Yes, we're always looking for comments, and we read when the next time that the committee meets. I will guarantee you, we read absolutely every comment that everybody makes. I'm not saying we do anything that we make a change because of it, but we do read them, and we consider them very, very seriously. But sometimes, sometimes the comment is just, it's something that'll apply 1 out of 1,000 transactions, and the form is a general form. So,
all right, we had a question from KW Corpus Christi, who I'm trying to get unmuted.
Yep,
You hear it?
yep. And then they are unmuted.
Okay, great. Okay, guys, go ahead.
It's a question about the feasibility period, also paragraph 7B2. That paragraph states that you have the ability to extend for a single period.
Yeah, somebody else asked about that.
Right, correct.
Okay, and we were collecting the names, I'm sorry, but if you don't use that paragraph, you can extend as many times as you would like. Is that correct?
Okay, so the question is the same feasibility extension paragraph. It says you can extend for a single period. And yes, that again, that's just the way the brokers on the committee decided they wanted it written for this first time through, is that it be for only one period. If you want it for multiple periods, you're either going to have to modify that paragraph or put something in special provisions. And you can do that. You can do that and still be within TREC rules. If your client says, I don't want it for a single period, I want it for 3 periods, then you can make that change to the contract. But what you cannot do is sit there and say, I advise you in a legal sense that you want 3 periods instead of 1. That's the distinction between practicing law and not.
Okay, if some of these circumstances and some of these deals, you really don't know if say an environmental study, you have to, you do phase 1 and all of a sudden you have to go to a phase 2. So now you go to extend, and phase 2 unfortunately calls for phase 3 and you got to extend again. You're not going to know at the front how many feasibility periods you would need. So if you don't use that paragraph, or if you use the strikeout option in zip forms and strike that entire paragraph and just stick to the first paragraph, can you technically still utilize as many feasibility extensions that you may need?
Okay.
Or are you still limited?
Right. So the question is, we learn later after the contract is signed that we need a longer feasibility period. That's basically what it is. And yeah, I mean, that happens all the time. This new paragraph is a pre-negotiated where the buyer thinks he's going to need it on the front end. You never know how much you're going to need until you start getting in and start reviewing the stuff. There is the commercial contract addendum has got a feasibility extension in it. I think, yes, it does. And so you just amend the contract before the feasibility period expires to extend the feasibility period.
Yeah, just that wording in that second paragraph, a seller might take it as, that's it, you agreed to this.
Oh, no, from a legal standpoint, that just because it says a single period, that's what you're negotiating then, is a single period. But you can always amend the contract. I don't care what the contract says. The buyer and seller can always amend the contract to say something different later if they both sign the same amendment. Doesn't make any difference. You're not.
I agree. It makes it tougher later, I think.
Yeah, I can understand that. Again, this is think of this clause a little bit as a trial balloon by the committee. They kind of want to see how people react to it, and it's gotten more reaction than I thought it would already, so that's good. So that's it. All right.
Thank you.
Next.
Any other questions live? No hands going up that we can see.
All right, we're going to take some typed in questions.
So we have, somebody in Arlington.
Oh,
Hang
no,
on, Arlington. Here we come. All right,
Last
Arlington,
chance.
you're live.
Hey, this is Art Rollator in Arlington.
Hi.
Question I have is in paragraph 25 of the commercial contract. In fact, I think the residential as well. Do you have to disclose if you are related to a grandchild? Not just a child, but a grandchild.
Yeah, the question is on the disclosure in the new last paragraph about you being a principal or being related to a principal. And that's the question was, do you have to disclose if you're related to a grandchild? And under TREC rules, the answer is no. It is child, not grandchild. And that is TREC's interpretation of the law. The legislature actually passed the law, and TREC, the way the legislature wrote the law is a little bit confusing, and it might include grandchild. But TREC is who enforces the Texas Real Estate Licensing Act, and you use their interpretations, and they decided we're going to stop it at children. So no to grandchildren. But you certainly can. I mean, you absolutely can disclose that it's your grandchild, but I don't think this legal opinion is you do not need to. There's a follow-up question to that.
Is that related to the lineal consanguinity issue that we run into in the states?
I'm sorry, you're going to have to say it one more time. I couldn't hear it.
Is that kind of connected to the lineal consanguinity issue that we run into in the settlement of the states?
Correct. And he used the word consanguinity for all of y'all who couldn't hear it. And that is the word that is used in the Texas statute as well. And that's the word that was causing some interpretation problems. And therefore, that's why TREC decided to specifically, it's easy for you to say, spell out parents, children, spouse, and yourself, and entities you own more than 10% of. But you hit the nail on the head with that.
Thank you.
All right, thanks. All right, unless we see any waving hands, I'm going to quickly move into some typed in questions. When a form is prepared by an attorney, is the agent responsible for making sure the form is in compliance with TREC rules?
Okay, if the question is in complying with the revised rule that I just listed, it depends upon who's bringing the contract to the table. If the seller or the buyer or the landlord or the tenant is bringing that form that's prepared by the attorney to the table, it doesn't need to comply with the TREC rule, because the TREC rule is when the licensee brings the form to the table. So if the licensee is bringing the form to the table, then the licensee had darn well better make sure that it complies with those things and has all those things in it. But if the licensee isn't bringing it, no, then you don't need to.
Okay. So, all right, additional extensions. Somebody asks, what if the extension fee is not to be considered earnest money? And I think this was about 1801 and 1802 as well.
Okay. And again, so the question is, what if the extension fee is not supposed to be considered earnest money? Then that new clause in the contract doesn't apply. It doesn't work. It was made narrow on purpose because that's what the brokers in the room wanted. Give your comments to that change, and we'll next time we revise them, we'll fix it up.
All right. Oops. Whoops, daisy. Requirements are actually principles. Yes, we talked about that.
She's figuring out the question.
Sorry, there's a lot in here. Texas Windstorm Insurance. Does the Texas Windstorm Insurance affect commercial in addition to residential?
It's my understanding that in certain circumstances it can affect commercial.
Okay. Last question from Matthew. Is it permissible to insert seller or buyer produced language in special provisions as long as it is not produced by the licensee? We oftentimes have customers that don't want to hire an attorney due to transaction size.
And the answer to that is absolutely yes. If a principal to the transaction wants to do it, they're not practicing law because it's them. They might have a fool for a client, but that's the whole distinction between a licensee practicing law and not. If the principal wants it in, then you put it in. No problem with that. You're not going to get in trouble with TREC. You get in trouble with TREC when you say, we have these standard clauses that we always want all of our sellers to put into the contract. Well, then you're practicing law because you're the one who's coming up with the wording.
Okay. Slightly different. Back to the feasibility period extension. The process is what we have always done this. By putting this in the contract, won't it encourage arguments that buyer has waived its right to an extension since the paragraph wasn't filled in originally? Conversely, won't it create arguments that buyer is planning on extending?
From a negotiation standpoint, yes, I can see where both of those might be correct. From a legal standpoint, no. You can always negotiate. You can always negotiate an amendment to the contract to say whatever you want the amendment to say, to change any part of the contract you want to change. So from a legal standpoint, I see no problem whatsoever. From a negotiation standpoint, yeah, it might cause you some issues. Maybe yes, maybe no. Again, that very point was discussed by the brokers on the committee when they gave the instructions on how they wanted it to be worded.
Okay. Somebody says, I've been told the IABS is not a part of a contract, but then it's listed on the list of additional forms attached to contract. Please clarify.
Ooh, excellent question. All right. And you are correct. the IABS is not a part of a contract. And it can't be, well, it is, but it shouldn't be, let me put it that way, because you're supposed to give the IABS out to the client or whoever it is you're talking to at the first substantive discussion about a particular piece of property. Well, hopefully you were talking to them about the piece of property before you were filling out the contract. I mean, so if you think it through, you're too late. If you're giving out the IABS for the first time at the time that the contract is being signed. And by the way, I say for the first time, you only have to give it once to any one person. But the thinking behind having it on the contract is basically better late than never. Today, I think commercial brokers and agents are much better about delivering the IABS form. When it first came out, y'all were horrible at it. Just horrible. Y'all didn't think it applied to you, and you were wrong. And there were plenty of people who got in trouble with TREC about it. But you get in a whole lot less trouble with TREC if you at least gave it, and gave it late, than if you never gave it at all. So that's why it was added as on what I'll call the checklist of things that most people read through that list, say, do I need this? Do I need this? Do I need this addendum? Do I need this addendum? Do I need this addendum? And a lot of people would see it and say, oh yeah, I never gave out the IABS and here it is. Well, we saved that guy's bacon because at least he gave it out even though it was late. And that's the whole reason behind it.
All right. KW Corpus Christi, I see that there's a hand up. Is that a leftover hand or does somebody have a question? It looks like somebody does have a question. I am unmuting you. Go ahead.
Or maybe not.
Or maybe not. No?
Maybe not.
I'm being waved away. Okay.
Oh, wait, change his mind.
Okay, go ahead.
I hope
You have to hold it down because it's on you. There you go.
Okay, all right. So my question is, early in the lecture, you're talking about the 4 things that your client needed during that objection time to the commitment before the time period starts up. And I just wrote 3 things down: the survey, the UCC search, and the title commitment. What is that 4th thing?
The 4th thing is actually the second one in the list, and that is the exception documents that are referenced in the title insurance commitment.
Oh, right.
When the title insurance commitment says let me back up for those of y'all who may not have heard that. So the question was, what are the 4 things that need to be delivered before the feasibility time clock starts ticking? And those 4 things are the title insurance commitment, the UCC search if required, the survey if required, and the exception documents that are referenced in the title insurance commitment. So if the title insurance commitment says the property is subject to restrictions of record in document number 2015-86754, well, you got to get a copy of document 2016-86754 so you can read it to figure out what the heck those restrictions are. Or if it's subject to an oil and gas lease recorded in volume 8, page 10, you got to get volume 8, page 10 to be able to read that document to know what the heck it is. You know, is it still valid? Is it, what's going on with it? So you got to get all those exception documents. In the residential arena, many title companies, most title companies, do not deliver the exception documents. And if you're doing a commercial transaction with a closer who does mostly residential, you're probably not going to get those documents until you ask for them specifically. If you go to a title company that specializes in commercial transactions, they will almost always give you those exception documents at the same time they give you the title insurance commitment. Many of them now are giving you the title insurance commitment with hyperlinks in them. So when it says document number 2018-6754, that document number is actually a hyperlink, and you can click on that and automatically download the document.
Cool.
Yeah.
Okay. Jed Kleppen, I want to say I have made a note of this title conflict. There are two forms that reference one another, and there's a conflict in the titles, and I'm going to hand that off to the attorneys and see if we can get that fixed.
Okay.
And then he also asks about, there was a red line for the commercial lease 2101, and there was also a red line for 2103 posted but not revised, and he asks if those are going to be pushed through. He said there was a new paragraph E, waiver of tenant's right to protest appraised value in 2103. So did we just decide to, I wasn't in that meeting. Do we remember? We may not remember that, Jed.
I
you
don't
know what?
remember. Yeah.
Jed, email me. It's agamber@TexasRealtors.com, AGAMBER, and I will find out the answer from one of the attorneys, and I'll get that back to you. Somebody, we're getting there. Someone asked you to define secured matter, which I think actually should be material. It was when you were referring to the wire fraud, I believe, secured material.
Oh, secured, no, I think it wasn't the wire fraud. I think it was the personally identifiable information.
Oh,
Could
right.
that be what
Okay.
it was?
Yeah.
Okay, so there's actually a statute out there about personally identifiable information. And personally identifiable information is what you need to be careful about. And when you get, every year you get these privacy notices from your bank, mainly from your bank, that talks about the private information. And they have to do that under federal law because they have your, quote, personally identifiable information. And personally identifiable information is defined by the federal government as being your name and another piece of information that can identify you. And that would be your birth date, your mother's maiden name, those kinds of things. Your address, can't think of all of them right now, but it's if you think about things that people, your social security number, things that crooks can put together and easily hack into one of your accounts or pretend to be you, that's the information you need to take extra care about.
Someone
I don't know if
asked,
that answered it or not.
I'm not sure. Can you add a notice from agency to contract and have principals sign that are not prepared from lawyer? I'm not exactly.
Don't know that I understood that question.
And I'm not sure this person is still online.
Okay, but let me answer what I think the question is. So the question is, can a brokerage house put a piece of paper in front of a client, I'll call it, to sign that has to do with something or another, basically anything? And the answer is yes. What you can't, you're practicing law if you're inserting yourself in a transaction between the buyer and the seller. If you are, if it's not between the buyer and the seller or the landlord and the tenant, and instead it's between the brokerage house and the brokerage house's client, well, you can do whatever you want with that. I mean, if you're saying, if you're getting them to sign a form that says, we acknowledge that you gave us this information, or we acknowledge that you told us to be careful about this or that, or whatever it is that is an agreement between the brokerage house and their client. Another good example is the listing agreement. The listing agreement or the buyer representation agreement. You can mark those up all you want to mark up because you're a principal to the transaction. It's a transaction between the brokerage house and the seller, or the brokerage house and the buyer. So, you know, you can mark up that. Hopefully that touched on the answer.
All right, we just have a couple more. Would it be better to mark through terms needing changes or just add them into special provision?
It depends. And that's the first time I've answered with that answer this time. If it's something super minor, then interlineating, you know, or striking through is probably the best thing. But if it's, you know, a sentence, a whole sentence, maybe it's better to go. The longer it gets, the better it is to put it in special provisions. Is the rule I use.
All right, I think this is our last question. Does the feasibility period not start the day after the contract is receipted, not when the title/survey is delivered?
The feasibility period starts when the contract is signed. Well, let me rephrase that. No, actually, to be legally correct, the feasibility period starts as soon as the contract is signed, even before the title company receipts the contract and you have an effective date, strangely enough. That's a very fine legal point that some people will argue with you, but you know, so think about it as just as soon as the title company receipts it, the feasibility period starts, and no one's going to complain, but technically, legally, as soon as the ink is dry on the contract, even before the title company accepts it, the feasibility period starts. It's that, and so maybe you've caught me because I said the clock doesn't start ticking on the feasibility period until you get those four things. And the way I should say it is the clock doesn't start ticking to tick to the end of the feasibility period until you get those four things. But the feasibility period starts immediately. So if you don't get those four things, if you got a 30-day feasibility period and, oh no, I'm so sorry. Let me say that again. I'm confusing the feasibility period with the title review period. The title review period, the clock doesn't start ticking until you get those four things. You can review the survey as soon as you get it, even though you don't have the other three. But the feasibility period, that starts, the feasibility period starts when the ink is dry on the contract before the title company even gets it. And the clock starts ticking to the end once the title company receipts the contract. So if you got a 30-day feasibility period and it's signed today, May the 15th, but the title company doesn't receipt the contract until tomorrow the 16th, you actually have a 31-day feasibility period when you get down to it. If that makes some sense.
All right. I want to thank everybody for sticking with us here to the end, especially Rick. Thank you so much. Let me go through a little bit of stuff. Next webinar, June 13, 2018. Yes, that is an RPR mobile for smartphones. You can find the registration for that on the TAR website. Our next commercial webinar is going to be on June 19th. It is going to be how immigration law affects real estate transactions, and it's going to be taught by Brett Huddleston of Huddleston Law Group in Texas, or in Houston. We did this class at winter meeting, and it was really popular and useful, so we're going to bring it back. There will be a registration email that goes out, and I'll post it on the Facebook group. Everybody check out our Facebook group, TAR Commercial. I also want to remind everybody that the Q1 market reports for 2018 from Reese Inc. are out, and they are chock full of useful stuff. You can find those by going to the commercial landing page on the TAR website. People are saying thank you, Rick.
You're
I'm
very,
also
very welcome.
saying thank you, Rick. And I am gonna call it a day. So
Excellent.
thanks everybody. We'll see you next month. Take care. And again, if, well, everybody here is, if you're interested in setting up a remote classroom at your office, like you can see some of those folks did today, you can get hold of me or get hold of John Hauser, and we are happy to help you set that up. So, all right, everybody have a great day, and do feel free to contact me if there's anything else we can do for you. All right, thanks everybody.
Thanks
Bye-bye.
everybody for your attention.